All right, I wanted to talk about gifting in regard to estate planning matters. So, when we're talking about gifting, it is a very broad subject, a lot of depth, a lot of intricacies. But what I want people to realize, it's one of those areas that you want to be very intentional about, and there has to be follow through as far as everything that's needed to provide what this transaction was. If it was intended to be a completed gift, everybody needs to know that, as far as who from the outside would be looking in and understand that that was the intention. So we have a donor and a donee. The donor is the person who's giving the property to the donee. So the donor has the specific intention of providing this gift to the donee. There's delivery of the gift to the donee, and there's acceptance of the gift by the donee. Now, various transactions involve gifting. So the most obvious would be just outright completed gifts to another individual. So whether that's real estate, business interests, cash, securities, bonds, etc. There's this outright gifting, it's done. There's other areas that involve gifting that aren't so obvious. So for example, you can set up a trust and you may have completed gifts into the trust, depending on what that looks like and what's desired. On the other hand, you could have a trustee who, when they distribute property to trust beneficiaries, at that point, there are completed gifts out to the beneficiaries. And what does that look like? You could even have a corporation or a partnership or a business entity that is transferring property to another individual, whether that's the shareholders or partners, and there are completed gifts in that fashion. So a whole host of transactions that could be gifts. And again, you want to be intentional about what is desired, because there are consequences both for the donor and the donee. Obviously, the donor no longer owns the property if there are completed gifts, and that may not be what is desired, because there are certain benefits that that person still wants from the property. So they do not want to do completed gifts to the donee. But if there are completed gifts, then the donor would be considering gift tax returns that need to be filed, and any gift tax issues, if there's going to be gift tax deductions or gift splitting with a spouse or valuing the gift, that needs to be considered at that time. Then the donee, if he or she is receiving that completed gift, is thinking, what's my tax basis now that I own this property? That's so important and so often gets missed. As well, what does the donee now need to think about now that he or she owns this property, good and bad, right? Has to be a time where there's this reflection that the person is now the owner of this property and what needs to be done both now and into the future. Now, as far as thinking about a very important estate planning document and gifting, I just wanted to bring out this idea that gifting needs to be thought about even at the time of basic estate planning, because basic estate planning entails preparing a power of attorney document. And what does that mean? It means authorizing other people called agents to act on your behalf in financial matters. Now, you may want to provide gifts in different ways, but what if you couldn't? Or what if you needed help? And now we're relying on that power of attorney and what the agents can or cannot do in the power of attorney. In that case, we're stuck if we don't have gifting powers, but the agent really wants to enter into gifting transactions. And when I say stuck, people don't realize everything, again, that falls under the umbrella of gifting. That's why I think it's such an important concept to talk about. Because I've seen matters where there's a dire situation, let's say, and we really need the gifting powers so that the agent can do X, Y, and Z. But if they are not in the document at that time, we are stuck. If the principal, the person setting up the power of attorney, can no longer execute the legal document, in other words, do another power of attorney document, we're stuck with what we have. And if we don't have gifting powers, but we really need gifting powers, there's nothing that can be done. And this came up just the other day where beneficiary designations on a life insurance policy needed to be changed, but could not be changed because the gifting power was not in the power of attorney. So gifting powers can include setting up a trust, funding a trust, handling business activities, entering into business succession agreements, even funding business entities that are currently in place or adding to business entities as far as gifting goes, handling joint interests, handling beneficiary designations, handling long-term care planning, handling asset preservation matters on behalf of the principal, and so on. So we go back to this idea of gifting being very important and you wanting to be very intentional about what you're doing, both when you are doing it yourself and what it means for you, let's say as the donor and the donee, and then what you would want in this very important basic estate planning document called the power of attorney and what powers you would authorize your power of attorney to have. You'll have your discussion with your estate planning attorney about the broad powers that you can include for gifting. You can also provide limits as far as who the permissible donees would be, the amounts that can be gifted, and so on. But it's so important to think about, even at the time of this kind of basic estate planning matter, that you think about such a thing as gifting. And that's why I do always say that people need to get started wherever they're at with estate planning matters, because if you started in some fashion with estate planning, it's only going to get better as far as your understanding of what can be done and what you want to have done. And it won't be your first blush at thinking of things like this. So no matter where you're at, get started with something and then get better as time moves on. If you're in the Western New York area and have any thoughts about gifting matters, please do reach out. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.